So good morning or good afternoon or evening to everyone joining us. Welcome to this webinar, which is hosted by the South Center, the intergovernmental think tank of developing countries based in Geneva. My name is Viviana Munoz. I coordinate the program on intellectual property and health issues at the South Center. For the next hour and a half, we will be discussing the interface of the protection of intellectual property rights and protecting and promoting public health, in particular for the timely and affordable access of medicines, vaccines, and other medical technologies for all who need them. We will be focusing on the international legal framework under the World Trade Organization, in particular the agreement on trade-related aspects of intellectual property rights known as the TRIPS agreement. How the TRIPS agreement relates to the global response to the COVID-19 pandemic, and drawing lessons from this, we'll be discussing what should be or may be the future of the TRIPS agreement. This webinar was initially meant to be a session at the WTO Public Forum, which was recently held in September. Unfortunately, we had to cancel because the Secretariat did not facilitate the virtual participation of our invited experts. And therefore, this webinar you might have seen was announced as a part 2, as it follows a 2021 session that the South Center hosted at the WTO Public Forum in 2021, where we focused on the TRIPS agreement in the context of the COVID-19 pandemic. So that session has been recorded and it is available on our website. We also linked it. You would have seen when we sent the invite for this session, and it's also available at the WTO website. So we are very pleased that we're finally able to have this incredible group of experts together for this discussion today. So thank you so much for being available again for this, and we hope that you will all enjoy listening to them. Let me then present our speakers. Anne Orford is Melbourne Laureate Professor and Michael Kirby Chair of International Law at Melbourne Law School. And she's also a visiting professor of law and John Harvey Gregory Lecturer on World Organization at Harvard Law School. Siva Tambisetti, who shortly will join us, is Associate Professor of Law at the Law School at the London School of Economics and Political Science in the UK. Fatima Hassan is a prominent human rights lawyer and social justice activist, and she's also the founder and director of Health Justice Initiative, set up 2 years ago, based in South Africa. Nirmalia Siam is a senior program officer at the Health, Intellectual Property, and Biodiversity program at the South Center, an international law expert. So with that, we will be starting our webinar panel. Our speakers will have each 10 minutes, and then we will be taking questions. So you'll see there is the Q&A section in the webinar where you can go ahead and start posing your questions. We won't stop in between speakers, so please do, we'll keep those afterwards and we'll ensure that we have enough time to take those questions. So Anne, we will start with you and start off by hearing a bit about the history of the TRIPS agreement and the model it established. Thank you.
Well, many thanks, Viviana, for that introduction. And I'd like to begin by acknowledging the Wurundjeri people of the Kulin Nation, the traditional owners of the land on which I'm speaking, and pay my respects to their elders, past and present. Thanks also to the South Center for the invitation to take part on this panel and to join such important contributors to this debate. I've given a longer talk which covers some of the issues I'll be addressing today as a Kirby lecture at the Australian National University. The South Center had linked to that from tonight's site, well, tonight here in Melbourne. So if you would like to follow the argument at a slightly more leisurely pace, you could take a look at that lecture. So the immediate context for this panel, of course, is the battle that's been playing out for the past 2 years at the WTO over the proposal first put forward by South Africa and India for a temporary waiver of aspects of the TRIPS agreement. And the proposed waiver had a broad scope. It covered diagnostics, treatments, and vaccines relating to COVID, and it encompassed all relevant intellectual property. It was co-sponsored by 64 governments, supported by over 100, publicly backed by more than 400 civil society groups, as well as the World Health Organization and UNAIDS. But it was blocked, as we know, by a small but powerful group of WTO members, with the EU, the UK, and Switzerland leading the charge. And that proposal was effectively displaced a year later in October 21, when the EU put forward a far more limited counter-proposal focused on clarifying, streamlining, and arguably narrowing the scope for using existing TRIPS flexibilities in relation to compulsory licensing. And in June, at the 12th WTO Ministerial Conference, a ministerial decision on the TRIPS agreement based on that more limited EU counter-proposal was approved. So my colleagues will say more about that ministerial decision and where it leaves us. Suffice to say, as the Medicines Law and Policy blog commented at the time, we are scraping the barrel now. But much discussion about the impasse at the WTO has quite properly focused on the spectacle of wealthy states prioritizing the monopoly rights of their powerful pharmaceutical corporations over public health in the rest of the world, particularly the global south. Despite the power of such critiques, though, the debate is still conducted largely on the terms offered to us by the TRIPS agreement, and largely treats the existence of that agreement and the property rights it enshrines as givens. But as we know, the COVID waiver debate is a symptom of a broader problem. The TRIPS agreement was a revolutionary agreement, in my view, and I'll explain why I say that in a moment, which established a deeply flawed global regime of monopoly rights. In this moment of disruption and change, both at the WTO and in the international legal order more broadly, it's time to talk about terminating that TRIPS agreement. So why do I say it was revolutionary? It came into effect in 1995 as part of the broad suite of new trade agreements that were negotiated as part of the Uruguay round, leading to the establishment of the WTO. And intellectual property had a long history in industrialized countries, but not in trade regimes. And indeed, most of the GATT Secretariat and the relevant trade delegations were not familiar with intellectual property rights. So the design of domestic patent laws, in particular, had always been a very complex political exercise, because patents create property rights in knowledge about inventions and give the patent owner monopoly control over the physical production of material objects from those inventions for a limited period. And states had traditionally designed their patent laws to achieve a balance between a series of goals that included rewarding inventive work, enabling the spread of useful knowledge, enabling access to essential commodities, and ensuring inventions were available for productive use. So that balance in the law could be met by granting patent holders exclusive rights to exploit their inventions only for a limited and short period, requiring that the patent actually be worked or exploited within the territory where the patent was granted, ensuring the invention was published clearly so that others could learn how to manufacture it, and limiting the nature of inventions over which patents could be granted to exclude essential commodities. So, for example, many European countries refused to grant patents over medicines until well into the 20th century, the 60s, the 70s, even as late as the 90s. And those that did grant pharmaceutical patents did so only for short periods and required the patents be worked or exploited within their countries. And in the 1970s, states such as India and Brazil also decided to exclude pharmaceutical products from their patent laws, facilitating the emergence of a successful generic pharmaceutical industry in those countries that's ever since threatened to expose the inflated prices of medicines. And finally, industrialized countries in the process of industrialization always limited the protection granted to foreign technologies. During the 20th century, we started to see a move towards internationalizing intellectual property rights, so allowing owners to exploit them not just nationally, but internationally. And the forum for debating how that would happen was the World Intellectual Property Organization, which administered a number of conventions on intellectual property. But those agreements governing international intellectual property were largely unenforceable, and maintained a compromise between the private interests of the patent holder and the public interest. But in the 80s, the US government began a campaign working with Pfizer and other major US companies alongside the EC in Japan to introduce a new US IP-style system on a global scale. And the negotiation of the TRIPS agreement was one of the most important achievements of that campaign. So the genius of the US approach in the Uruguay round was to link global intellectual property rights with the enforcement mechanisms of the new trade dispute settlement. So TRIPS provided for compulsory minimum standards of intellectual property protection, including patents. The terms of patent protection required under TRIPS is 20 years, which is longer than existed in most countries if they had such protection at all. It required detailed domestic measures for enforcing those rights, and there was no requirement to work the patents in the territory. So that meant that patents effectively turned into mechanisms for securing exclusive rights over export markets globally. So all of that was already controversial at the time the agreement was negotiated, partly because states foresaw the potential effect on access to medicines and food. And those concerns were in theory addressed by the reference to flexibilities at various places in the agreement, including the section on compulsory licensing. However, attempts by states to utilize the supposed flexibilities built into the TRIPS agreement have been routinely met with the threat of expensive litigation at the WTO and by other forms of investment and domestic arbitration. And I am sure my colleagues will speak further about that. In addition, the TRIPS provisions require member states to engage in cumbersome and lengthy negotiations with newly empowered patent holders who continue to show little interest in meeting governments halfway. And the COVID pandemic has provided numerous examples of that. So the spectacle of a handful of powerful companies based in Europe and the United States claiming property rights to innovations resulting from the collective work of modern science and using those rights to control the pace of manufacture and thus the price of pharmaceutical products is not an unfortunate side effect of the system, but the goal of the system. So why did states sign on? TRIPS was a strikingly bad deal for most states. Most had nothing to gain and much to lose from signing it. Most countries, other than the US, are net importers of technological and cultural information, and they all were therefore persuaded to pay more for it. So why did they sign on? So this matters for the issue of termination, to which I'll return in a moment. But they signed on for three reasons. First, they did so because it was part of a single undertaking or broader package. So the agreements negotiated during the Uruguay round were treated as a single undertaking. And in brief, that meant that states had to sign on to all the agreements if they wanted to join the WTO. Second, and most importantly, one of those important agreements was the dispute settlement understanding, and WTO members undertook to resolve their trade disputes through the newly created dispute settlement mechanism overseen by the appellate body. And the willingness of the US in particular to submit its complaints to that system rather than rely on unilateral sanctions and trade remedies was a significant factor in the decision of many states to sign on to the WTO agreements in general and the TRIPS agreement in particular. And now, of course, the US has walked away from that commitment. It's blocked appointments to the appellate body, and it's reinitiated actions under its Section 301 provisions. And finally, states signed on to the agreements because they understood that TRIPS included a set of exceptional measures, as I've already mentioned. So what's to be done in conclusion? The current push for this waiver has been made to seem radical, and yet it simply involves returning to a default position that was dominant only 25 years ago. So is that bad luck? Was this just a bad bargain? Is this now a situation where the US and the EU won in 1994, everyone else lost, and now people in other countries have to be sacrificed to uphold these property rights in perpetuity? So unsurprisingly, my answer is no. That's why I think we need to talk about termination. So international lawyers have a tendency to think about this moment in which states are withdrawing from and terminating treaties as a bad thing, as involving a threat to the international rule of law. But enabling change is part of what lawyers do. Commercial law transactions always envisage that a contract may need to be terminated. In domestic law, we take it for granted that cases can be overturned or legislation can be reformed. The only form of law which tends to be more difficult to change is constitutional law, but even then most constitutions have mechanisms for revision. So international law does provide mechanisms for terminating or withdrawing from treaties, and I'm happy to talk about this more in the Q&A. But I would say in brief that the circumstances in which states made that bargain that led to signing TRIPS have fundamentally changed, providing grounds for termination. The US has torn up its part of the deal. Resort to the meager flexibilities of the TRIPS agreement have been blocked systematically, and the WTO as an organization has proved unable to balance intellectual property rights and public health. And I would argue that these give grounds for terminating or withdrawing from the agreement, and that it's time to do so and to terminate this failed model of global monopoly rights that it champions. Thanks.
Thank you very much, Professor Orford, and I'm sure there will be many follow-up questions coming. With this, I'd like to invite Professor Siva Tambisetti. Thanks for joining us. So we've heard already proposal for and the rationale for potential termination of the TRIPS agreement. Professor Tambisetti, if you could follow on telling us, for example, what would be some important areas in addition to the possibility of termination, areas of reform of the TRIPS agreement granted this context. You have the floor.
Thank you, Viviana, and thanks also to the South Center for this twice convened panel discussion. I'm very pleased to be following from Professor Orford's few minutes. I've long been envious of our public international law colleagues because of the sophisticating cycles of meaning making the field has been through, including holding on to a sense of direction of the world order, perhaps, and a self-conscious understanding of normative scholarship as a transformative project. I think in contrast, international intellectual property law has by and large remained mired in its private law origins, unable or unwilling beyond some very important but limited pockets of understanding to confront how these rights might benefit existing power structures. To my mind, it's indeed significant that the first intervention during the pandemic by an eminent public international lawyer is to call for the termination of the TRIPS agreement. Now, while I'm excited to respond to the idea of terminating it, I think the TRIPS agreement is more than just an agreement. So, and if there is no single it that can be terminated, where does that leave us? So I begin by laying out three, and because of the very short time, I have highly truncated arguments, why I think the TRIPS agreement is immune to termination as an extreme case of being immune to change. I end with two further points on what we might begin to do to make its worst elements irrelevant. So my first point here would be to raise the TRIPS agreement and international intellectual property law as a sort of mode of argumentation. It's a shorthand for a cluster of ideas, formal rules, norms, epistemic assumptions and values, different elements that are often lumped together in a way that protects each of them from normative and empirical scrutiny, even to the extent that such scrutiny exists domestically. The opacity of this clustering has made it very difficult to have good faith disagreements over the last 2 years. There are any number of examples. Let me just give two examples. The first is the equation of the moral basis of property with moral arguments for intellectual property, which misses all sorts of nuances about the instrumental nature of these rights. A second idea is the way in which the public interest tends to get equated with the patent holder's interest. Legal doctrine in patent law assumes that they are aligned or can be aligned even where itself evidently cannot or will not be aligned. Complex ideas like these are folded into a mode of argumentation that protects such ideas from scrutiny, making these deeply entrenched in the practice of international law and diplomacy. My second point is about an inability to internalize notions of harm. I think a powerful impetus for change in any system is an understanding of the costs of not changing. Intellectual property statutes do not have any way of linking harm to the system's failings to account for those who are left invisible or fall out of supportive frameworks, unlike, say, international human rights law or the law of war. When people who have very little have even less, the suffering caused by the latest denial of access to, say, a life-saving drug or vaccine is not theorized as a consequence of the existence of the IP right or the constraints attached to it. Hence, the system requires vast amounts of suffering, millions of deaths to be moved, to be amended, or indeed terminated. It suggests a high degree of immunity to change that is not crisis-led or driven, making the status quo much more likely. And when there is no recognizable crisis, we get socialized into ever-increasing levels of scarcity. I think here the work of people like Tahir Amin and Preeti Kishtel in linking high prices of drugs and in access to the existence of patents is incredibly important because it allows us to name the tangible harm that is caused by formal IP rules. The third point I'd like to make here is something I'm calling collateralization. International law increasingly interacts with IP in all sorts of negotiating fora and intergovernmental organizations. Lawrence Helfer, in a key paper in 2004, saw this expansion of IP matters as regime shifting by developing countries who are actively seeking to recalibrate the TRIPS agreement. When new norms are being negotiated or old ones are sought to be reinterpreted in these diverse fora, what we're finding is that contrary to what is suggested by the literature on regime complexity that says there is no hierarchization of international agreements, there is a de facto deference to IP rules that is squeezing the negotiating resources of developing countries. Collateralization arises, for instance, when there is a bid to defer to the WTO or WIPO as best place to make rules on international IP or interpret them, or when there is inertia that prioritizes a past way of doing things over future, more appropriate and socially justifiable legal norms. Here, I would bring my experience as an observer on the biodiversity beyond national jurisdiction treaty negotiations, or the high seas treaty negotiations, as it's sometimes called. Here, there is an opportunity to create new norms for use and circulation of genetic resources. Elements of this process is, however, blocked by key countries who benefit from the status quo. This could be through a blanket refusal to discuss IP, by not granting enough negotiating time, or by disaggregating issues according to what is easily resolvable first, and then getting to the really controversial issues such as IP later, and then finding ourselves hemmed into a position that makes reopening IP irrelevant or futile. Collateralization is also a feature of reinterpretation of norms and can be seen in processes that see, for instance, disclosure of origin of genetic resources in patent applications, or the use of traditional knowledge mired in WIPO negotiations for years, even decades. So collateralization is a systemic feature of the international system set up by the TRIPS agreement and makes a system far more resilient than we might otherwise expect. So what might we do? I think it might be easier to begin the process of starving the TRIPS agreement of oxygen rather than terminating it. And two strategies, just very quickly, that we might consider to do this are as follows. The first is private ordering and regional arrangements. When we focus on IP rights, we focus on the exclusivity it creates to the technology product. But in my view, there is a much bigger form of scarcity that accompanies the IP right-led monopolies, and that is the exclusive leverage to make social choices and generate socioeconomic relationships around the technology. This power is different to market power, something Hilly Gardner terms as configuration power. Developing countries during the pandemic have not really been able to call on the private sector's self-organizing capacity and diverse motivations during the pandemic, because these are currently exclusively centralized around the IP rights a key player may hold. And there are not many ways in the collective imagination of how to free this power to configure relationships from IP-led centralization. And this is where private interests framed by public values can come in. Not all companies might want to make blockbuster profits. Some may just want a sustainable way to enter a new market. Some may be keen on playing the long game and building technical capacity and resilience. So IP rights are one way to facilitate the involvement of the private sector, but as we saw in 2020, there are other ways to do so. Advance orders, public sector investment, export controls. even the confiscatory levels of compulsory licenses, the likes of which we saw from the US as widely now reported by the KEI. So in that sense, a plea for the TRIPS waiver was, in my view, a plea to allow greater degrees of private ordering around relevant technologies on the part of governance and cash-poor developing countries. A corollary to facilitating private players, in my view, is to create stable or sustainable markets and to leverage existing exceptions and waivers in order to carve out such markets. And I think here regional arrangements are critical: pool demand, pool supply, and pool responsive regulation to address governance problems. So my second point here would be to increase microprocesses of lawmaking. Again, public international law has a rich narrative and understanding of informal processes of lawmaking, which is almost entirely lacking in international IP law. It remains hyper-codified, sealed, impervious to outside critiques, with a dense set of technical rules, recourse to which is often used to shut down any exchange that tries to elevate the discussion to a principles-based one. And here, microprocesses, I think, can recreate the kind of injection of public values that we might see as common in other kinds of property holdings. In patent law, to give you some well-known microprocesses that would fit this description is Section 3D in Indian patent law, South Africa's research exception that has allowed Afrigen to reverse engineer Moderna's vaccine, and Brazil's Anvisa that can prevent or inhibit the grant of medically important inventions. These microprocesses are the inside man of the system, making legitimate and incremental changes that do not raise hackles in the same way that outsider critiques may. So that's my very brief take on the kind of future for the TRIPS agreement I would like to see. Thank you.
Thank you, Professor Tabisetti, and that was definitely brief, but packed with many ideas and a lot of analysis. So do everyone listening feel free to bring your questions again to the Q&A to follow up. So I think we've heard important related concepts about the legitimization of power through international law, but also how powerful nations use their political power also to bend the law. Now, in terms of the future of TRIPS agreement, two ideas: one of termination, another call for starving it of oxygen. So with that, I'd like to turn now to Fatima Hassan. And if you could tell us also about your view on the negotiations to limit the impact of the exclusive monopoly rights provided for under the TRIPS agreement, and how the current negotiations as well may play out, and what can we do?
Thanks. And if somebody could just help me with time so that I don't exceed the 10 minutes. So, I just want to reflect on what Anne and Siva had both shared, and I think it's such brilliant contributions. And if you haven't watched Anne's Michael Kirby annual lecture, I really urge you all to watch it. But we've been saying for some time, even during the HIV/AIDS crisis, and then more forcefully during the COVID crisis, that the WTO is not fit for purpose. And by that, we mean that one of the key agreements that is part of the WTO architecture of international trade rules and the way in which it's governed, and we might add in a not very democratic way, not with a lot of clear transparency and with a lot of secrecy, and what Third World Network has called side negotiations in green rooms. But basically, I think what COVID has showed is that TRIPS is also not fit for purpose in serving public health strategies and public health needs. And I'm going to explain why that's such a strong kind of view that many of us have. But I want to go back to July 2020, because I think one of the key pieces or submissions that were made by the South African government before the waiver proposal was tabled in October of 2020 was a submission that it made to the WTO in July, warning, based on what had happened already with HIV/AIDS and many other epidemics, that the TRIPS flexibilities would not be sufficient to deal with a global pandemic of this magnitude. And I mean, aside from the magnitude and the crisis of death it created, there's also a socioeconomic crisis of food insecurity, job losses, financial losses. The entire world basically experienced simultaneously because of this pandemic. But the submission said that the use of TRIPS flexibility to address a public health concern is usually seen as a matter concerning patents. the COVID-19 pandemic requires a more integrated approach to TRIPS flexibilities that includes other various types of IP rights, including copyright, industrial designs, and trade secrets. And those issues are less understood at the national level, and that national IP laws may not even provide for sufficient flexibilities to address issues of access. And that's why all of the different IP rights are relevant in the fight against COVID-19. And then the submission went on to say that many developing country members may also face legal, technical, and institutional challenges in using TRIPS flexibilities. And to that list, I might add, obviously, trade pressure as well, or political pressure. And the submission then went on to say this is especially true for countries that have never utilized flexibilities such as compulsory licenses. And then one last part of the submission, which I just wanted to highlight, is that it reflected on so-called regional pooling mechanisms or technology access pooling mechanisms, for example, including CTAP. And already in July 2020, it kind of forewarned of what was going to happen, which is something the DG of the WHO has already reflected on. And it said that such mechanisms call on IP holders to share their technology, to cooperate voluntarily, to issue voluntary licenses. But those mechanisms are not actually serving the purpose for which they have been established. And I think we've seen that with the way in which COVAX has also played out. And the submission stated that at that point, but even up until now, except for the Spanish government, nobody's actually provided their technology into the pool, that no company has committed to doing so. Instead, limited, exclusive, and often non-transparent voluntary licensing is the preferred approach of pharmaceutical companies, which will be insufficient to address the needs of the current COVID-19 pandemic. And so this is, a reflection of July 2020, which the South African government used as the basis for actually calling for the TRIPS waiver. Unfortunately, what we saw in the negotiations, and this has been very carefully explained, and there's been really good record keeping by organizations such as MSF, as well as the Third World Network, is that we saw significant delays in the negotiation, and then what I have called gaslighting. And the gaslighting really has come from a block of countries that are in the EU. We saw the way in which the EU Commissioner also responded to the negotiations, particularly within the EU. I think specific attention has to be focused on the German government, and then the Swiss government, the UK government, and then obviously the US. So essentially what we were left with was a deal that many of us have called a bad deal, and a deal that was a slap in the face for poor people, but a deal which basically really mirrored what the US had indicated that it would only support, and that is a partial waiver on some of the conditions in the TRIPS agreement related only to vaccine for a limited period of time. And that is basically what the Biden administration had actually supported already by May of 2021, which many of us thought would be a breakthrough, but in fact what it did was to curtail the negotiations, to limit it only to the conversation about vaccine. So, I mean, all of you know that, the waiver was calling for all IP to be temporarily suspended for the duration of the pandemic. This is a right and a possibility and a mechanism that is included in the TRIPS agreement. So this was not something outside of what we already consider to be quite constrained rules of the TRIPS agreement. This is a measure that is available in exceptional circumstances for a specific period of time, which the TRIPS agreement is supposed to and meant to recognize. But the opposition that we saw to a very simple proposal that would de-individualize or what I call de-individualized responses in a global pandemic was just really shocking. And I mean, we've isolated some of those countries that have created that kind of pressure, and also lobbying from the pharmaceutical industry on those governments, which stories are only now emerging of the extent to which they were able to exert and influence political power in the way in which these negotiations were dealt with. So what you had was a solution to try and encourage the freedom to operate across multiple jurisdictions for all COVID-19 technologies, for all IP elements, not just patents. And particularly, I think we need to focus on issues around trade secrets and copyright, which was basically blocked. There were 65 co-sponsors at least, 100 countries supporting it. And even though the WTO sort of imagined itself to operate on the basis of consensus, what we saw was a consensus of the wealthy and a consensus of the powerful. It wasn't really the consensus of the 65 co-sponsoring countries from the global south. And I think when we talk about gaslighting, what we mean is the EU's counter proposal. We had a submission from the South African government in July. Many countries have historically basically complained about how difficult it is to use the flexibilities of the TRIPS agreement in a time of a public health emergency of international concern or in a time of a pandemic or epidemic, yet those very measures were being presented as an ideal solution for each country in the global south to use at the time of a global pandemic for all of the different technologies. And we're not just talking vaccines, we're talking of diagnostics, we're talking of therapeutics, we're talking of access to ventilators, etc., as well as PPE. And so the result is there's been so much focus and attention on vaccines, and I think that's by design because that is what the US government is really pushing for, to limit the, whatever bad deal eventually was negotiated was just limited for vaccines. And I mean, the only exception or the only sort of silver lining to the eventual deal was that there's no export limit. So it's started out as asking for a waiver of 35 articles of the TRIPS agreement, but there was only a partial waiver of one part of a subsection that is contained in the TRIPS agreement around export limits. And I think that, for those of us who were on sort of the front line and trying to support our government to try and push for the TRIPS waiver because we were left with very limited supplies or not timely access, and most of us don't even have access to adequate therapeutics at the moment in the global south. What was quite surprising was the way in which the WTO Secretariat and the DG's office then operated after the 12th Ministerial Conference was postponed because of Omicron. And you remember that many of us were meant to fly to Geneva at the time. We were going to have this in-person conference, and that was postponed. The push from civil society was to have at least virtual resolution of the TRIPS waiver, or if some of us were even asking for a vote, which is also permitted in terms of the TRIPS agreement. But because of this idea of consensus, it's hardly ever used. And that leaked, that consultation, that WTO Secretariat text really laid the basis for what's called the Quad Agreement or the side agreements, and eventually a culmination in a very bad deal. The net result of that is that they still within 6 months of signing of that deal or conclusion of that agreement will come and still negotiate and have discussions about extending the waiver potentially to diagnostics and therapeutics as well. So where South Africa started out in July 2020 and where South Africa and India had kind of articulated a particular vision of how we're going to address the issues of access in this pandemic, learning from the past in the October 2020 proposal to what we have as the resolution or the so-called bad deal, I think are definitely miles apart and poles apart. And Third World Network has really written a lot about what is happening in terms of process. And that is why I previously argued that this entire negotiation, the entire way in which the WTO is structured, also based in Geneva in the global north, the unprecedented power of a handful of rich countries and a few pharmaceutical company CEOs is distorting democratic traditions and democratic processes at an international level, but also at the domestic level, because you can't basically take the necessary executive measures domestically without the possibility of jeopardizing or compromising some trade relationship that is happening with multiple trade ministers, culminating in decisions around fisheries or agriculture. And I think that Anne is right. What she referred to in her lecture was that the system has created this very unfair deal-making process, and you have winners and you lose. You have winners and you have losers, because sometimes you get a good deal and sometimes you get a bad deal. And that is why we are arguing that the WTO and the way in which it's currently structured is not fit for purpose, because in the middle of one of the most unprecedented global pandemics, we had one of the worst deals that the WTO could actually negotiate and facilitate and offer, because of the vested interests of a handful of powerful nations and a handful of corporations. And unfortunately, you can You can write as many articles as you want, and you can frame it in whatever positive narrative you want, but we have to accept and we have to agree that TRIPS, the way in which it's currently functioning, centers big corporations and their powers. And in this instance, it centers the power of the pharmaceutical corporations. And one of my friends and colleagues, Amy Kupczynski at Yale University, has just written a brilliant piece on how that systemic power, I think, feeds into sort of an international system of norms and of rules. I mean, Joseph Stiglitz, Professor Joseph Stiglitz, the Nobel laureate, has called TRIPS at the, when the deal was announced and we were critiquing it, has said that it's basically a system that is ethically indefensible. And so I actually, am leaning more towards the end argument that it's time to terminate. So let me conclude by saying, what is the net result? Where are we now? We have no waiver of all of the different IP elements for all of the technologies for the duration of this pandemic. It's now 2.5 years into this pandemic. We got a really bad deal, which is limited to only vaccines and with a number of caveats. And the only thing that it really lifted with the export restriction. We have limited flexibility currently being used by developing countries in the global south for one or other reason, either political inability or the executive is really scared of trade pressure and what it would mean for concessions on other deals, fishing, agriculture, IT, big tech, etc. We have limited voluntary measures. We're being told that all of our access issues must just be dealt with through voluntary licensing with partial agreements on some therapeutics, on some diagnostics for certain jurisdictions, not for all jurisdictions. For example, excluding Brazil from a voluntary license for Paxlovid, for example, where CEOs are still in control over the response of public health in this pandemic. So we've basically gone full circle and we've come back to the same point of monopoly power and really a deference, not just located in the WTO, but I think in all of the multiple institutions that we're seeing and all of these so-called mechanisms to try and address equity. It's a deference to IP monopolies, and it's a deference to the idea that innovation must be rewarded with a lifelong pattern that allows you to extract as much power and also as much profit as you can. I mean, we all know about the overnight billionaires of this pandemic. So I want to end off by saying that we're in a really perilous situation for access going forward and for the idea of decommodifying life-saving technologies. And if there isn't a reset, and if there isn't quite a radical, I would say, reconfiguration, then we're just going to be in the same situation, having the same conversation for years to come. You can't respond to a pandemic in such undemocratic ways and with such a lack of transparency and so much of secrecy. Thank you.
Thank you so much, Fatima Hassan, for brilliantly elucidating what was the process of negotiations of the TRIPS waiver from the perspective of activists and the role that civil society organizations also strongly have played also in providing information, in particular to the broader public as well, of what's been going on in the process, so to also be able to influence and participate. Of course, there is that concept of gaslighting in the process and of leaving partners obfuscated during the negotiations. And in conclusion, we've heard as well the perspective that the TRIPS waiver so far has not been optimal. It was a bad deal. So with that, I'd like to follow now with my colleague Nirmalia Siam, who can perhaps tell us also a bit more of the context whereby we hear that the TRIPS agreement has enough flexibilities within public health so that the solution is just to use those. We've heard, of course, our colleagues already saying, well, definitely there's also structural systemic issues that shows that's not the case, and the solutions we needed were also not made available. So if you could tell us about that, and also the relationship with the TRIPS dispute settlement overall system of the WTO. Thanks, Nirmalia.
Thank you, Viviana, and good morning from here in Geneva to all of you colleagues joining us from around the world. With regard to the argument that there are existing flexibilities in the TRIPS agreement, which could be made use of in the context of public health emergencies of the nature of the COVID-19 pandemic that we are continuing to experience, it would be important to bear in mind that the flexibilities, while they're there, and the Doha Declaration has clearly stated unambiguously that countries can use the flexibilities to the fullest extent. But the decision to use the flexibilities involves both political and commercial considerations. For example, the use of a compulsory license would require the pharmaceutical company making use of that compulsory license to seek for one, for example, and that would that company would do that only upon consideration of its commercial ramifications, given the fact that it has value chain relationships with multinational pharmaceutical companies, which have actually sort of evolved more after the TRIPS agreement was adopted, and governments were trying to sort of use the flexibilities in certain instances quite aggressively. I'll take this point in relation to also the, what Shiva referred to as microprocesses, the use of microprocesses for making, for inserting public values into the narrative of the TRIPS agreement. And she did mention Section 3D of the Indian Patent Act, the research exception in South Africa, the Anvisa model of Brazil. Some of these are also, as you are all well aware, under a lot of stress. For example, in FTA negotiations, there is this constant pushback against using these microprocesses, or what we would also call as making use of the flexibilities that are existent in the TRIPS agreement through these microprocesses. And then, of course, there are the political pressures, which the UN High-Level Panel on Access to Medicines a few years before the pandemic actually had pointed out was being extensively used, the Special 301 reports. The European Union also has adopted its own model of this unilateral coercive measure strategy. This is in addition to the threat of a dispute settlement challenge, which always hangs like a sword of Damocles over the decision to use any flexibility or implement laws defining the scope of the flexibilities domestically. Now, in that context, it's therefore important to A, look at what are the flexibilities that could be used to the fullest extent, and B, how do you make use of those, and what you need to do within the TRIPS agreement and outside the TRIPS agreement in the context of associated WTO rules, for example, in the dispute settlement understanding, or for that matter, adoption of authoritative interpretations under Article 9.2 of the agreement establishing the WTO. So we are aware of the pre-grant and post-grant exception flexibilities that are available under the TRIPS agreement. The most important pre-grant one, as we have been pointing out at the South Center, being the use of rigorous standards of patentability in examination of pharmaceutical patent applications. Because if you are able to screen out the egregious patent applications that are sometimes filed, typically you would actually have less of a problem to deal with at the post-grant stage, where you would have to think of compulsory licensing options and use of other flexibilities. In an environment which is not facilitative, given the political and commercial interests at play, which cancel it out. In the context of the post-grant flexibilities that could be used, one important flexibility that is there in the TRIPS agreement is the use of parallel importation on the basis of the application of an international regime of exhaustion, because Article 6 gives the freedom to WTO members to define their own regimes of exhaustion of rights. And countries could, for example, adopt an international regime of exhaustion of rights and undertake parallel importation. However, in practice, what we have seen is a large number of countries, WTO members, have subscribe to what is known as the consent theory of parallel importation. That is, the product which you would import after you deem that the patent right has been exhausted could only be done if the product has been put into the relevant market by the consent of, or with the consent of the patent holder. So under his license, for example, under a voluntary license. Now, this is not actually required in terms of what is in the TRIPS agreement, and nothing restrains countries from adopting a more expansive doctrine of parallel importation where you don't have to subscribe to the consent theory. In fact, the laws of some countries, India, for example, Pakistan as well, allow for parallel importation of a product where the product has been put into the market of into any relevant market through any legitimate means. Pakistan, in fact, specifically mentions including compulsory licensing. So these are options that could be used. One needs to look at how do you facilitate the exercise of a parallel importation regime and address those. And we have elsewhere discussed those most recently at the Global Forum on IP and Access to Medicines that the South Center had organized. So we could perhaps address those if you are interested more during the Q&A. Then in terms of Article 30, another important exception that could be utilized, which the South Center has also pointed out in one of its recent papers, is the use of manufacturing for exports under Article 30. And nothing in our reading in Article 30, under Article 30 of the TRIPS agreement prevents countries from making such creative use of the exception under Article 30, even if you apply the three-step test, which as was stated in the declaration adopted by the Max Planck Institute a few years back, it does not have to be applied cumulatively. So there could be a much more flexible interpretation of Article 30 than, for example, was adopted in the Canada patents case. Thirdly, then I would turn to the issue of dispute settlement. Now, one of the issues that's hanging in terms of the TRIPS agreement is the issue of non-violation and situation complaints, and whether the moratorium on non-violation and situation complaints should be made permanent. The interpretation that is being advanced by the United States and Switzerland in the TRIPS Council discussions consistently has been that unless the moratorium is extended, non-violation and situation complaints would become applicable to the TRIPS agreement, which I would submit is an incorrect interpretation, because it is explicitly stated in the agreement, TRIPS agreement itself, that any decision on extension of the moratorium or on the scope and modalities of non-violation and situation complaints has to be taken by consensus. So unless scope and modalities are agreed to by consensus, something cannot be applicable. That would be a literal reading of the text itself. Then, more systemically, with regard to dispute settlement, as I mentioned, a lot of the meat of what we would call as flexibilities are derived from an exercise of interpretation of the TRIPS agreement. Who interprets the TRIPS agreement when it comes to its national implementation are obviously the countries. Article 1 of the TRIPS agreement clearly says that countries decide on how to give effect to the provisions of the TRIPS agreement and the means of their implementation. So that's how countries, for example, could adopt a provision like Section 3D in India. Now, the issue is when if it comes to a dispute settlement challenge in the WTO, the panels would enter into an exercise of interpreting what your obligations under the TRIPS agreement are and whether you have given effect to that obligation in your national law. Now that exercise involves, it raises the question whether there should be a national deference standard or a national deference principle in the interpretation of the TRIPS agreement. It has been argued by a number of scholars that in relation to TRIPS-related disputes in the WTO, the standard of interpretation should be based on a national deference standard. Now, Article 17.6 of the Agreement on Anti-Dumping actually writes in a national deference standard for interpreting disputes in relation to the agreement on anti-dumping. It's important to note that when the WTO agreements were adopted, at that point of time, the negotiated understanding was that this provision of in Article 17.6 in the agreement on anti-dumping would be given consideration to for further expansion to other WTO agreements. Now, if that discussion subsequently never really happened, now it's important to take a step back now and take a look at whether such a principle could be enshrined within the TRIPS agreement. That would be one agenda of reform, perhaps, that we could also advocate. The other issue to point out is with regard to the waiver. Given the fact that we've got a suboptimal waiver, more important to note is that in the middle of perhaps what is the greatest public health crisis of our times, it took us more than 2 years to negotiate a suboptimal deal. In terms of a performance appraisal, perhaps that's the nadir. And therefore, perhaps it would be important to look at an inbuilt automatic trigger waiver, which could be linked to future declarations of public health emergencies of international concern or pandemic in the context of the reforms also that are being discussed in the WHO to the international health regulations and the pandemic treaty discussions. So those were some of, finally, I would also add one more point is with regard to the coercive unilateral coercive actions, such as the 301 declarations, etc., which have a chilling effect on the use of flexibilities. Perhaps it would be useful also to give consideration to whether in part 3 of the TRIPS agreement, in relation to enforcement obligations, an obligation, thou shalt not do section 301 sort of an obligation could be inserted. Currently, you have obligations on how states should provide remedies for infringements, etc., and what kind of actions should be or facilitation measures should be put in place for enforcement. But perhaps one important issue that we need to look at is how do you facilitate enforcement of flexibilities? One of the barriers towards facilitating such enforcement of flexibilities are unilateral coercive measures, and also perhaps TRIPS plus measures in FTAs and investment agreements as well. So a provision in the enforcement section, for example, which restrains parties from adopting to any such standards or any such measures could also be given consideration to. Thank you.
Thank you, Nirmalia, also for your inputs for this discussion. So to everyone listening, we have come to the end of the presentations. So now we'll be able to engage with you through the questions that have been posed. So just for the benefit of our panel, I will note some of the issues that have been raised so far in the questions. And for those listening, do feel free to add your questions in the Q&A box. So one of the issues I think that perhaps several of the presentations by Professor Orford, Tambisetti, and also, of course, by Fatina was raised is about the need to generate a movement for more fundamental change or even termination of the TRIPS agreement as coming out as messages. And one of the questions that's being posed is if you could reflect again, what could be some of the sort of activity that could be done to generate this kind of movement towards these deep reforms or towards termination in the context of what we've seen with the TRIPS negotiations. There's been, of course, important initiatives such as those by civil society, and what else could be done if you have concrete ideas of how can we move forward on these processes. So feel free just to either take the hand function or just go ahead since we're a small group. Maybe I could start with you, Fatima, as you've been very much engaged on the civil society movement part of creating sort of this more systemic considerations being raised by civil society, not just on the nitty-gritty, technical elements of the agreement, but really saying here we have to do something broader. How do you see what could be a way forward to broaden that debate?
So, I mean, I think Stephen's right about taking the oxygen out of TRIPS, and is also right about it's time to build local domestic campaigns to insist that particularly governments in the global south try and figure out, which will be a 10 or 20-year process. This is not going to be quick and overnight, right? If you look at how long a simple waiver discussion took to actually exit the agreement, or at least I think to start with the low-hanging fruit, using the pandemic as an example of why the way in which we apply the rules of the TRIPS agreement to medical technologies, at least that has to be different. I think there has to be an acceptance that the flexibilities are insufficient and are very difficult to use, particularly compulsory licensing, and that has to be the starting point, that even the flexibilities are not fit for purpose. And we saw that with HIV/AIDS, we're seeing that with COVID. I mean, in my own, in an ideal world, you wouldn't have a World Trade Body, and I see Preeti's question about, whether bilaterals are preferable to an international trade agreement. But when you have an international trade agreement and a system that is designed to protect, certain vested interests, and it's so clear. I mean, I think it's been so clear in the last 2 years that you even have academics, Nobel laureates, world leaders, all really reckoning with the fact that we're now in a situation where this is not working. So this is no longer a radical call from a small group of activists. I think there's a worldwide global moment, and we have to use that. Now, there's some debate around, do you use the current discussions around reform of the WTO to introduce these aspects? What is the correct process? It's a very difficult moment to try and figure out what is, I think, the right way to do this, because you have a secretariat and a DG that is so defensive, and that is in their mind and in their imagination serving the poor and serving public health needs. So I think, the strategy also has to be dealing with the location of the WTO, the political realities of the DG's office, of the role of the WTO Secretariat, and the expectations on that particular office on a whole range of other interventions. So yeah, of course, not an easy process, but just the last point, domestically, what we said to our government is we supported you for 18 months on the call for a TRIPS waiver, but now we're going to hold you to account for signing a really bad deal. You negotiated this bad deal. You're not using the flexibilities. You're not taking executive action, even on the mRNA hub, and we can talk about that later around some of the IP risks. Why, what are we getting as South Africa out of being a member of the WTO? What are the concessions? Because why are we part of this process when clearly there are major limitations and major weaknesses? So yeah, those are just some ideas. We'll leave it there.
Thank you. And would anyone else like to take?
Yeah, if I may go, Vivian, I hope that Luke was to say to go ahead. So I wouldn't start with generating a movement. I think movements draw attention, and where questions of legality are concerned, it becomes a different sort of fight. So I would like to talk more about a velvet revolution, where you do this softly. And I think Nirmalia Sham's presentation was incredible with the amount of expertise that already exists for the measures that can be taken to begin to starve this agreement of oxygen. And it's going to be very difficult, I think, to generate a worldwide a movement or what is indicated by that term movement, because there isn't a collective that shares all priorities and interests anymore. And I think this is something that the G77 group plus China, for instance, is deeply divided depending on, the interests that are aligned with each other. There are elites in each country that align more with the elites in other countries. There are links between generic companies and other generic companies that also should be recognized. So there's a lot of intermeshing of interests that make it, I think, quite impossible to generate a sort of movement that would suggest that all our interests are equally aligned. And I think this is troubling. And that's why the language of collective action, sort of exploding into fruition, I think doesn't work. But what can work, I think, are regional arrangements and exploring those exceptions, those waivers, using expertise. And I'm often taken aback by how much expertise, how many thousands of words are written on interpretation of the TRIPS agreement that never then get implemented. So the gap between the legal case that can be made and the political will to put some of these solutions into place, I think, is quite a big gap. And organizations like the South Center, I think, do a great job of trying to bridge that gap. But there needs to be more political gathering, organization around some of these solutions and goals, and that's quite difficult as legal scholars for us to generate that kind of movement. For instance, when CIPLA produced those ARV drugs for $1 a day to deal with the AIDS epidemic, it seems almost impossible for a CIPLA now to emerge from the global south. And we might want to look at why and how that situation has come about. I think low-hanging fruit, in my point of view, would be to generate test cases. I think Afrigen is a test case. I heard a presentation from PPP saying that they're not sure about how they would create a sustainable market because there is still the threat of patent infringement. So, for instance, it would be an idea perhaps to create a regionally carved out market based on exceptions and waivers being used regionally in order for Afrigen to have a sustainable market. So I think we do this with test cases. We do this by proof of working out in small cases, and then we wouldn't really have to talk about a movement.
Thank you, Professor Tambisetti. Professor Orford?
So I would like to say something about why I would put termination on the table and then how we might think about getting there. And just to say, I just learned so much from the earlier speakers. It was, my head was going 100 miles an hour, so it's fabulous. Thank you so much. But let me just come in kind of back on this point of termination. So one of the reasons to put it on the table, I think, is that the property rights that these pharmaceutical corporations are given through the TRIPS agreement gives them not only control over decisions about production and thus price, which is the flawed model of having patent regimes that operate globally and aren't worked in different countries, and so therefore are not kind of contributing to the expansion of the capacity to use the invention. So the combination of those rights giving control, but also then giving more power within the system. So these are now rights holders who are able to lobby and have more resources, but also more legitimacy. And the sense we have is that well, that's just a fact in the world now. But kind of coming to this as an international lawyer and a generalist, of course, this is just an agreement. It's a transaction. You enter into it and you can leave it the way you could a contract. It's not a constitution, although we're encouraged to think of it like that, but it really isn't. And so then the question would be, well, what are the rules that relate to terminating or withdrawing from a treaty? So in the case of the WTO, it's kind of tricky because the separate agreements don't have clauses that relate to termination or withdrawal. You have to rely on the WTO agreement itself, which would require a state to withdraw from the WTO. Now we might, I think, and Fatima, you've just been making the argument, I think, for many states, there may be good reasons to withdraw from the whole situation, but others may not want to. They may think, well, I'm getting quite a lot out of this, but this agreement is bad for almost everyone. And remember, there's almost no state in the world that is benefiting from TRIPS. It is giving global property rights to a very small number of corporations. So if we turn to general international law, then you can have a right of withdrawal or termination if there's been a fundamental change of circumstances, and it's a similar idea in contract law domestically. And here I think we are really seeing something like that. So just to take one example which picks up on Namalia's point, you know, there is something akin to what you're talking about in terms of what you'd like to see added in Part 3 of TRIPS, thou shalt not do, Section 301. And it is the WTO agreement itself and the dispute settlement understanding. They were explicitly set up and included provisions in which states undertake not to use unilateral remedial action. They commit to bringing their laws domestically into conformity with these agreements. And indeed, you know, this was brought in relation to Section 301 back in the day, I think in the late 90s, where states said, why is Section 301 still on the books in the US? It wasn't using it at that point, and it undertook never to use it. And that panel said, oh, well, we have to rely on that statement by the US that they'll never use it, so it doesn't have to be taken off the books because it's made that undertaking, and we will treat that undertaking as binding, relying on the nuclear weapons case in which France promised not to keep nuclear testing. So there's, you know, an example where in fact the WTO did defer to a domestic interpretation of the US. It didn't, of course, do that when it came to India's domestic interpretations of its implementation of TRIPS later on. So we can see then that the US has walked away from this key basis for which many states signed on to this agreement. And under this principle of rebus sic stantibus, fundamental change of circumstances, we can see that there have been circumstances that existed at the time of conclusion of the treaty that have radically changed, radically transformed the obligations states have entered into. So in a perfect world, states would all agree to terminate it because it's rubbish, but they won't. But still, you can withdraw, and it could happen bit by bit, not all at once. And of course, we're seeing this debated right at the moment in relation to the Energy Charter Treaty, with the European states now rethinking the extraordinary agreement they forced the post-Soviet world to enter into, now seeing that it's going to bite them in terms of the capacity to decarbonize, and now thinking about a kind of mass withdrawal or rewriting. We are seeing this all over the place at the moment, and one of the reasons is exactly the situation of natural and physical instability that did not exist in the 90s, or at least we weren't as aware of it, and it does now. And I would say that is, in fact, another fundamental change of circumstance that we are going to be managing. So these agreements, we don't have to be stuck here. You know, how to actually make that happen, I must say, is not my necessarily strong suit, but there's so many movement lawyers here that I'm very happy to hand that across.
Thank you, Professor Orford. So as mentioned by everyone, political will being a critical factor, and we also see that bilateral investment agreements and FTAs are also being revised and some terminated. So as you mentioned, it is possible, and these context issues are changing. So important that it's not just a big dream or big potential, but that it is actually possible. Nirmalia, would you like to add anything on that point?
Well, I would fully agree that it is legally possible if there is political will to go in that direction. It is legally possible to look at treaty terminations or even withdrawals and revisions. In terms of revision of the TRIPS agreement itself, I mean, amendment itself, incidentally, Article 10 of the WTO agreement allows for any member state to submit a proposal before the ministerial conference or the General Council, or also in the relevant councils in relation to the annexed agreements, the multilateral agreements, which includes TRIPS, to submit proposals for amendments to the agreement. It does not have a clause on termination inside on the face reading of it at the moment that I've seen. But of course, in international treaty law, as Professor Orford pointed out, that is very much a possibility that fully recognized under Article 62 of the Vienna Convention on the Law of Treaties. And it could be also replaced by subsequent treaties in that regard. Thank you.
Fatima, you wanted to come back, please?
Yeah, I mean, I think firstly, this agreement is not 100 years old or even 50 years old, right? This was like an agreement that was forced onto countries in the global south and many other countries in the 90s because of the role of Pfizer. I mean, Tyra, Amin, and many of our colleagues have written about the very pernicious role that companies, pharmaceutical companies that are based in the US decided to basically create a system where internationally every single country, irrespective of their own constitutions and domestic needs and public health needs and scale of epidemic and epidemiology and HIV prevalence, etc., were compelled into a system where they decided the dates by which every country must basically make sure that their domestic laws are in line with the TRIPS agreement. I mean, we were part of a group of civil society activists in India at the time when the clock was ticking for them to pass those laws. I mean, those lawmakers didn't want it, but they had to because there were other trade pressures that were basically being placed on them. South Africa, I mean, we became a democracy in 94, and then we had to become a member of the WTO in 95, which many of the provisions in the TRIPS agreement goes totally against the provisions of what we have in our constitution, right? So this is a man-made agreement, and literally a white man-made agreement. The CEO of the pharmaceutical companies have decided that they want to extend their monopolies over life-saving technologies, over products that they are not even fully funding. I mean, the R&D, we haven't even talked about that. Like, whose IP is this? I mean, the political idea and this existential kind of crisis that the pharmaceutical industry is facing, that they feel that they have to evergreen their patents and extract, unbelievable amounts of profits over public goods, and genuine public goods, because the public is actually participating in the clinical trials and participate, and putting a lot of public funding. So I'm going to mention the C word here. And I think we have to call it colonialism, all right? And for us, this represents a very colonial construct of how the empire decides it's going to regulate trade, and how, in the old days it was ships, right? And now we have plants. So I think quote that I quoted it in my Calgary talk as well about what the UN Special Rapporteur has said. And I think we have to be brave enough to keep on reminding the DG's office and all of those trade negotiators who are residing in Geneva, telling us about how you need to reward innovation, etc., and that the only way you can do it with the TRIPS agreement is that the very, basis of this model is replicating colonial patterns and structures, and it's totally unfair and it's totally undemocratic. And if a group of men can create an agreement like this, then a group of women and a group of activists and a group of researchers and thinkers can, I think, work towards fundamentally changing the way in which we deal with this. Because the hub it's just one small thing in the bigger scheme of things that you can do. We really need more sustainable ways of trying to scale up manufacturing on essential technologies. So I think it's not just legally permissible. I think it's politically necessary. We are in an existential moment in the world where, I think Anne reflected on this in her talk as well, is that if you have a system where even with this rules and the agreements and the negotiations and a whole international agreement that you can't expeditiously share technology in the middle of a global pandemic, this is an unprecedented pandemic of COVID, then they're not going to do it for climate change, which obviously explains, the German government's opposition, the UK government's opposition to the waiver. This is our moment, not just for health justice, but I think for climate justice as well, because there's going to be no broad sharing of technology. I mean, I've mentioned before, not a single company 2 years in a global pandemic has come into CTAP. Not a single company, Pfizer or Moderna, is cooperating voluntarily with the mRNA hub in South Africa. So I think this is what we're going to expect, that, replication, I think, of colonial patterns. And I mean, we feel strongly about it because we were colonized. We've experienced this. We know what that kind of system looks like, and I think this is just feeding into that, and it's time for rethink.
Thanks so much, Fatima. Now, another element of the questions that are being introduced is whether we should be looking at other areas of international law, in particular human rights law, and also other multilateral fora, so the world of the World Health Organization and negotiation taking place there, including the regular resolutions that can be advanced, but also in the context of a new pandemic international instrument. Should we be focusing also efforts over there to deal with these intellectual property issues? And with that, I'll just tell the speakers as well, we'll be giving a round of about 2-minute intervention generally, and then we'll do our wrap up. So who would like to go first on this issue on WHO and human rights? I think we would all agree generally that this is very necessary. A sticking point usually is that question about, well, can we reform TRIPS from movement in other multilateral fora, or do we need us to just take a parallel approach and seek that we can have coherence between what we are saying is needed and what actions we're taking actually in these interrelated fora, and hopefully have secretariats that are assisting in those processes as well in a coordinated manner. And of course, the role of the World Intellectual Property Organization as well in providing the adequate technical assistance when we are asking, for example, to facilitate use of TRIPS flexibility and to highlight the legal, the legality of the use of the TRIPS flexibilities. And furthermore, we've generally said we also need to call out those systemic issues and those systemic pressures on countries not to make use of those existing flexibilities. So with that, I'll just turn in order as we started for if you want to address this question or just generally give your key takeaway points you think of both of what you have said, but also of reflecting from what you've heard from colleagues here. I'll start perhaps with Professor Orford, please.
Okay, well, thank you for those questions. And of course, we can only touch on them really briefly here. So on this question of should we be looking to other sites as well as the WTO, of course, that is the case. I think what's important, though, about focusing attention to the WTO and to this agreement, and I'll mention in a moment Siva's important point about what she called collateralization, I think, but the kind of expansive way in which TRIPS kind of is embedded, or TRIPS ideas are embedded elsewhere. But just to take this question, so I think one thing so I take a lot of guidance and, inspiration from human rights critiques of what's been happening. But I think the problem with looking to human rights kind of fora is that they don't have the kind of enforcement mechanisms and the kind of capacity to shape property rights that the WTO has. And so often I think we see human rights look to, or other areas like human rights law look to mediate the worst excesses of these property regimes. But property rights structure the societies to begin with, and they structure relations between persons, which we then kind of look to human rights to fix up for us. I think it's important that we address these key values as a central part of the property regimes that we're maintaining and defending, not look to human rights for kind of solutions and take the property rights for granted. And in fact, we've seen in international law many examples of laws emerging that limit the rights of property holders. We could think of the emergence of the norms prohibiting slavery or apartheid, or the fact that you used to be able to use force to collect debts. And all of those things were outlawed eventually in international law. So there's absolutely no reason that we can't revisit these property rights. And I think it's important to do that at the kind of place where they're created, as well as coming back to talk about their effects on human rights. And just to take up Siva's point, which I didn't have a chance to touch on, I think is a very important one. And I think it also appeared in one of the comments by, in a sense, by that's, I think, gone. But so the question then of, can you really deal with it through TRIPS when there's, of course, now various FTAs and other regimes that are kind of embedding similar TRIPS or TRIPS plus provisions? And that's, of course, absolutely true. So in a sense, this is a kind of starting point. But I do think to kind of come at TRIPS is to come at the place where this first is introduced into the international trade world, and it would have an enormous impact on the capacity to keep embedding this in other agreements, and the sense of legitimacy that I think these TRIPS provisions have, which assume that they're just the baseline and then there'll be even more and more protection. So I think it's such an important point to kind of think about the way in which this is embedded in all sorts of other places.
Thank you so much. Professor Tambisetti.
Thank you. So the first question about taking this discussion to other lateral sites. I think what we've seen in the last 18 months is a failure of that strategy. The WHO could not have been more vocal, could not have been more incisive about the way it has criticized the international patent system, international intellectual property rules during the pandemic. The fact that it has had so little effect, perhaps you could say that the effect it has had is that we did have the waiver negotiations, we did have that discussion. But the fact that it has not had even more impact, I think, is very telling. And for me, confirms a suspicion that the regime complexity, as we understand it, doesn't really exist. What we have is a virtual hierarchization of intellectual property law internationally over all sorts of other agreements and all sorts of other arrangements in international, in intergovernmental organizations. And I think for me, that's a key takeaway lesson from the pandemic. So I'm afraid I'm very, I have very low expectations of other sites of engagement with IP, including human rights. We've seen very robust interventions again, and I think people like Fatima are so important to the stories that need to be told about access to medicines and vaccines. We've seen the Committee on Racial Discrimination come out with a very strongly worded statement. These are all welcome interventions, but I'm afraid they are perceived by the international IP system as outsider critiques. And there is very little margin, there is very little pathways for these kinds of interventions to have an impact in the way the property rights are structured. So I agree with Professor Orford. I think we need to focus on the site where these property rights are created and make our persuasive cases in that site. It's about how the patent system is structured. It's about how trade secrets interact with patents. And that's where I would take my fight. Final takeaway, I think it would be a mistake to think of the TRIPS agreement as just being a WTO fight. The TRIPS agreement is embedded in all sorts of sites, and we need to take the fight to every instance where it's used as a mode of argumentation. Thank you.
Thank you. Perfect. Fatima, to you.
Yeah, so I mean, I'll tell you a funny story. Some of you may know this, but in the Dominican Republic, there's an attempt to get a compulsory license against Pfizer, which is being resisted. And Pfizer argued that it has human rights. The corporation has human rights, and that its human rights would be infringed if the license were to be granted. So I think we're also in this really dangerous phase of beyond the WTO and TRIPS agreement. What you have is pharmaceutical corporations now appropriating the language of human rights and trying, what I call mission creep, right? And I think we have to warn against it. So if there is another site of struggle, it's to safeguard, in many domestic settings, the constitutional domestic jurisprudence not to extend human rights protections to a pharmaceutical corporation. And we're seeing that with banks, we're seeing that, with oil companies, etc. Because the other issue in their idea, in their mind, is that compulsory licensing is conflated with expropriation, without compensation, which it's not, right? And that's a very convenient narrative. If you are stealing my technology, you're taking it away, there's no money being paid. Whereas in fact, the entire voluntary licensing and compulsory licensing mechanism is about, making them even, greater profits because they would get a reasonable royalty on that. So, and then the second, which we can all laugh about, but I think is really worrying, and that circles back to the issue of power, right? And so I think Siva's right about the difficulties, because any attempt to try and deal with the WTO and TRIPS agreement is going to invoke, massive lobbying power, like we saw in the TRIPS waiver negotiations. Look at the lobbying and marketing budget of those companies that try to influence political leaders to resist the waiver and to prevent governments from outright, openly supporting it. So we heard many times off the record conversations with government leaders from all over the world. Of course, we support it. It's the middle of a pandemic, but we can't because we just got, their boss got a phone call from the CEO of Pfizer or J&J or Moderna, etc. So these things are actually happening. And so the US Pharmaceutical Industry Association does an annual submission to the US Trade Representative. And I think last year's submission, they complained about the WHO, about UNAID, about every single multilateral institution that was calling for equity in this pandemic, and said those institutions are trying to undermine their IP rights, right? So I think there is already quite a clear and significant tension between the way in which the industry sees the role of the WHO and even UNAID. And then just finally, we've used as human rights lawyers at the height of the HIV/AIDS battle, we couldn't rely on the international global trade system. We couldn't rely on the TRIPS agreement. We couldn't rely on compulsory licensing, and we couldn't rely on any kind of voluntary licensing or voluntary measures because the companies were just simply refusing. So what we used instead was competition law. And I think that is an underexplored area because that is the one other site where you can at least try with limited tools to regulate the way in which market power operates. And one of the key things about holding the pharmaceutical industry to account is using competition law to ask for the full disclosure of R&D, to say, fine, okay, I am reluctantly agreeing that you are the IP holder and you have the market monopoly, but in order for us to determine whether you are committing any kind of antitrust abuse or whether you are exercising dominance in a way where you are overcharging on a product, make all your R&D available. Let us know what it truly cost you to bring this product to market, and then we will give you a fair and transparent price. And that is the way in which we got, first-line ARVs, voluntary licenses, and generic entries into South Africa. It wasn't because of executive action. It wasn't because of the voluntary action of pharmaceutical companies. It's because they were scared when you use access to information laws and when you use competition law to try and actually get to the bottom of what is really going on. So for an industry that claims to believe in transparency and rule of law and it wants all of its rights protected, we as patients and as consumers can say, well, then you need to disclose your full R&D and all of the different, contributions to clinical trials, to funding. And so that's when we get into the whole ecosystem, right? Which is why it's not just about patents and it's not just about trade secrets. It's the entire ecosystem of how these trials are being designed in our countries, how we are being exploited by having to participate in these clinical trials, and then and then there's no prioritized or timely or affordable access. So I think an intersection of competition law, what you call antitrust law in parts of the global north, and then constitutional law. And then, finally, for all of the South African government and Indian government, push for the waiver, like what was it doing domestically? Like, we asked the South African government negotiating, if you sign this bad deal, tomorrow what happens? How does this protect the hub? How does this make sure that we get access to Paxlovid diagnostic? It doesn't. So unless you deal with the failures of executive action of some of the countries in the global south, then I think, we're not going to get very far. So, and that's why it has to be civil society led, because you've got to hold pharmaceutical corporations to account, vested interests in the global north, and then our own governments to account as well.
Thank you, Fatima. Nirmalia.
Thank you, Viviana. So I would agree with the suggestion that we should keep the focus and be targeted in the context of WTO and look at reforms in the context of TRIPS specifically, what we need to do over there. But at the same time, it's important to recognize, as Shiva has pointed out, that the TRIPS agreement is embedded in other forums, in other agreements, and we need to address it there. But not only that, I think one of the issues that I recall was mentioned in one of the webinars I had attended at the beginning of the pandemic also was the fact that nowadays, in terms of discussions that happen in the UN, we do not see a lead role played by the ECOSOC. For example, in the entire context of COVID-19 pandemic, we did not see much of a discussion of issues happening in ECOSOC. In fact, much of the initiatives that were rolled out, etc., happened outside the ECOSOC in forums such as the G20, etc. Now, the point is that in these forums, the developing countries that are there are not in great numbers. And therefore their united voice is not there. They're marginal players in the context of other bigger developed countries with whom they're negotiating over there. And therefore, it would be perhaps interesting to look at keeping the temperature on this, raising the temperature on these issues in the UN with a coalition of developing countries, a united coalition of developing countries, perhaps in the ECOSOC, which would perhaps push things in forums such as the WTO as well in a positive direction. It is important to recall that, for example, in the 60s and 70s, some of the major developments, gains that the developing countries got, for example, the Declaration on the New International Economic Order, Charter of Economic Rights and Duties of States, were outcomes of a movement that developing countries as a united force pushed in the UN. And that led to UNCTAD and other institutions, which WHO also, for example, the Almaty Declaration, etc., was an offshoot of those processes. Of course, in the 80s, you had the WTO coming in as a pushback against these initiatives that happened. So I think we need to rest that initiative back and keep the temperature, raise the temperature over there as well in the ECOSOC, if it were to be possible. That's a strategic thought, perhaps. I would leave with that. Thanks.
Thank you, Nirmala. So thank you all so much. This has been a brilliant opportunity to listen to you all. I'm sure I reflect that for the attendees as well. And there's so much content to review. For that, we're happy to tell you that we do have the recording that will be made available so that in your own time, you can go through all the rich discussion that is taking place. So thank you so much. We hope this won't be the last, but actually the part 2 of many other parts that we need to have these discussions, that we'll have you again with us. So thank you very much, and do check in South Centre website. We'll have the recording, and we have other avenues available for you, in particular to the policymakers who wish to follow up. We'll also make available not just this, but as you know, the resources we usually do that may be useful for you also in these negotiation processes. Thank you so much. Until next time.